Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, welcome back. Today we are in Callaway County with Social Security disability attorney Jeff Roberts, and we're going to talk about something that we referenced in the previous episode, and that's where you may have a workers' compensation claim that actually turns into a disability claim. And Jeff, you handle both of those, luckily, which is not something that every law firm does. But let's dive into this because this is a nice kind of way that you positioned the firm over the last 33 years. Let's talk about that.
Sure, Jim. Good to see you again. I do handle both cases, and unfortunately, frequently a person may have both claims going on. I have seen over in my career and represented several people over my career who, because of a work injury, the work injury is so severe that they were totally disabled as a result of that injury. And in those situations, then they not only have the workers' compensation claim, but they may also and frequently also have a Social Security disability claim as well that they can pursue from that perspective, and vice versa. I've had people come in over a Social Security disability claim, and that's the reason they wanted to talk with me. And then I talk to them about their situation, and then ask them, how they become disabled, and find out they had a work injury, and that's what led to their disability, and they weren't aware of the workers' compensation claim. So it's gone kind of both ways from that standpoint. But generally, it's the work injury first, and then the Social Security disability claim develops after that. And what I tell people frequently that come in to talk to me about Social Security disability, and when I'm discussing it, one of the things that a lot of clients will tell you I have told them at some point in time is, because frequently a lot of people, they want to get back to work. They don't want to be disabled, and I understand that. I would be the same way. And I tell them that you're better off physically, mentally, and financially working if you can work, but if you can't, then we need to make sure we're taking care of your future in that regard. And with workers' comp, one benefit of workers' comp is if you're off work as a result of the work injury initially, then you should be getting what's called temporary total disability benefits, which is the lost wage benefit, one of the lost wage benefits under the Workers' Compensation Act. And that will pay you until you reach maximum medical improvement or until you're able to go back to work, whichever occurs first in that regard. So, that gives you money to pay your bills while you're off.
Some money, at least, right?
Some money, yes. It's not your full wages. It's a reduced rate, 66 2/3%, subject to a cap in Kentucky. But at least it gives you some money coming in to pay all your bills and keep the lights on, keep food on the table for your family in that regard. But this goes on for a period of time, and then it becomes a question of whether the person is going to be able to get back to work. That's when I have to have the conversations with the clients about potentially filing for Social Security disability benefits. And I have a lot of folks who have a pushback when I first talk to them about that because they want to get back to work, and I want them to get back to work if they can.
Well, I think you've said in the past, in previous episodes, that if you can go to work, I mean, it's good for your emotional, your psychological. It's good for a lot of financially. It's a better deal, usually. But some people, it's just a point of pride, right?
Right, exactly. It's a point of pride, and it's. I don't know about the younger generation because I'm not part of the younger generation. I know my generation that we, in the generations before us, my father's generation and grandfather's generation, we took a lot of pride in providing for our families and in the jobs that we do for people or for a living from that standpoint. And then when you take that away from somebody, it is very, very damaging to them psychologically from that standpoint. And I've had conversations with several people in my office when they finally come to the realization that they're never going to get back to work, and that's a difficult realization for a lot of people to come to there. And I don't like, like I said before, I'd prefer my clients to go back to work. I don't want them to be totally disabled. But unfortunately, that's not the way it is all the time. So sometimes we have to do that. And I'll tell the client, and there's times we quote unquote protectively file the Social Security claim. For Social Security disability, you have to be off work, you're expected to be disabled for a minimum of 12 months. So, if somebody has a back injury, they're having surgery, and we don't know what the recovery is, I don't tell them. A lot of times I don't say, let's file a Social Security claim. I say, let's wait and see how your recovery is, because hopefully you're going to recover and go back to work. And you've got the workers' comp check coming in. If it's a situation where I think it's, I'm not quite sure they're going to be able to get back to work, they've had a multi-level fusion in their low back and they do a very heavy job, I may tell them in that situation, let's kind of protectively file the Social Security disability claim. It's going to take a long time for that Social Security disability claim to go through the entire process.
And I think that probably surprises people, because a comp claim, you can kind of get that rolling fairly quickly, and that temporary total disability, benefits check starts rolling in, and okay.
Correct.
Social Security disability is not like that at all.
No, you don't get anything until it's finally approved. They don't pay anything to start with. It's after it is approved, and unfortunately, most of the time you have to go to an administrative law judge, which is the third level of the process, to get it approved. So, you make the initial application. Statistically, you're going to get denied in about 3 to 4 months. You file an appeal of that called a request for reconsideration. Statistically, you're going to be denied again in about 3 to 4 months. And then you file a request for hearing in front of a judge. That's where the cases are granted. But frankly, you're looking at about a year or so before you're in front of that judge. So you're looking at about a year and a half or so on that process before you actually are successful and start getting a check coming in from that standpoint. So in the times, if it's a 20-year-old who had the back injury, and I think, well, let's play it out and see how things are with them, because being successful in a Social Security disability claim for a 20-year-old is extremely, extremely difficult anyway.
Because age can be a factor in some of these claims.
Age definitely is a factor in that. But if you've got a 56-year-old who has done heavy manual labor their whole life and they had a 2-level fusion, their ability to bounce back from that is going to be much more difficult there. And we may want to protectively, so to speak, file the Social Security disability claim a little earlier than I would recommend for the 22-year-old, just because I know their ability to get back in the work market at 55 and never done a sedentary job, don't have the computer skills to do most sedentary jobs from that standpoint, is going to be there. And there's going to come a point where the workers' comp check is going to stop. Whenever they reach maximum medical improvement, if they never reach a level to return to work, hopefully they do, but if they never reach a level to return to work, when they reach maximum medical, the workers' comp is going to stop that temporary total disability, and it's going to be a period of months before we can get permanent disability benefits and get any more money for them in their workers' compensation claim. So if we can get the Social Security case started a little earlier than what I might normally would do it, and hopefully have that process and approved by the time that the workers' comp check stops, and then it's the safety net. And that's what I tell them. I said, even though you may not want to, and I hope you're able to get back to work and you're still in a period of recovery, let's get this safety net, work on getting this safety net in place for you. And if you're able to get back to work, we just drop the Social Security claim, and we don't, Social Security does have a trial work period. So you have a 3-month trial work period. So if you try to go back to work, and you're able to work only about a month and a half, and then it's bothering you so much that you cannot keep on doing it, it doesn't cost you your Social Security disability claim. It's called an unsuccessful work attempt. And so that's fine to do that. in that
And ultimately,
regard.
I would think the government would want you to try to get back to work if you can.
I would hope so.
Yeah,
Yes.
yeah.
Yes. And that's, I encourage my clients to do that. If they see, and I tell them frequently, if you see a job out there that you think you can do, go try it. If you're able to do it, great. We'll drop this claim. Don't worry about it. If you're not able to do it, then we'll go into the judge. It makes my job a little bit easier in front of the judge. Say, Judge, he doesn't want to be disabled. He's tried to go back to work. He's not able to do so, or he or she is not able to do so. So taking advantage of that is beneficial, can be beneficial there. And if you're able to, that's wonderful, because you're better off physically, mentally, and financially working if you can.
Well, let me digress for just a minute and talk about attorney's fees. You don't charge anything up front. So, I mean, for them to do that provisional claim, it's not costing them anything up front anyway.
Correct.
Yeah, so
Yes.
that's a pretty good strategy for the worker.
Yes, and I've had some clients come in and say, "Well, you've worked on this Social Security claim. I don't really want to, I don't know that I want to go back to work because I don't want you not to get paid." And I tell them then, I said, "Don't worry about that. You go back to work if you're able to do it. That's great. I'm happy for you. It cost me a little bit of time, but you're working, and that's more important to me than my fee is in the case." From that standpoint, and so
That's a perfect example right there of the motto for the firm. You want to talk about that for a second? Because I mean, I really, it's funny that people, you see billboards or you see different advertisements and people have slogans, but you have a motto, and that case that you just talked about is a prime example of this. And I've known you for a lot of years. It's one of those things you don't like to brag, but I mean, I like to point this out because if we're not doing it, they may not be aware of it.
Well, yeah, my motto for the office is to provide small town service, deliver big city results. And I was born and raised in far western Kentucky, and my mother, father, grandparents instilled in me that you help people out, and in western Kentucky we do.
Absolutely.
Yeah, if you've got a neighbor in need, you help them out. I don't know how many times I've heard of farmers around here where one farmer had some kind of health issue, and all the neighbor farmers come and got their crops out for them and helped with that in that regard. That's the way we do things in western Kentucky. That's the way I was raised. And frankly, that's the way everybody needs to. It shouldn't be just western, and it's not just western Kentucky. Don't mean it that way.
Yeah.
But that's
definitely what you know.
that's the way. Yeah, that's the way I was raised, and that's frankly to me that's a great way to live. From there, and I know the same is there. If I need help with something, I've got neighbors that's going to come help me if I needed help with something from that standpoint. And I got lawyer friends. If I had a health issue and needed somebody to come help me at the office, they'd do it in a heartbeat.
Yeah.
And so but that's just kind of the way it is. We do things because it's the right thing to do. And again, people getting back to work. I've sat and I've seen the impact of not being able to get back to work and what it means to a person and how difficult it is for people and how financially struggling it is for them from that standpoint, not just clients, but family members in that regard. So I'm always encouraging my clients to, if they can, try it. If you can't do it, we'll deal with it from that standpoint, but don't worry about my side of it. That's I took the case on a contingency, and if we lose the case or don't win the case because you're back at work and you're able to work, that's great. I'm happy for you. So.
Oh, that's fantastic. So, Jeff, we talked about, again, if this is stemming from a workplace injury, you're going to handle the comp claim, and that temporary total disability payment is going to come in fairly quickly. But at some point, that's going to end at maximum medical improvement.
Right.
Sometimes you'll actually file that Social Security disability claim when you think there's a reasonable reason to do that. And then again, that will hopefully kick in and provide that safety net. The other thing that Social Security disability allows for is back pay. Do you want to talk a little bit about back pay?
Yes. Like I said, it takes about a year and a half. A lot of times, not every case takes that long, but a lot of times it takes about a year and a half to be successful in these cases. Sometimes it takes even longer than that. But when you're successful, it doesn't mean they just start paying from the date they find you disabled. They'll pay back pay. For Social Security disability, they pay back pay 1 year prior to filing. So if you file February of 2026, then they can pay you all the way back to February 2025, assuming you were disabled back then. You know, if you become disabled in July, they don't pay back prior to you becoming disabled. And there is a 5-month waiting period that we'll talk about in a second. But so they will pay back pay 1 year prior to filing for Social Security disability, which is what we're talking about here. Now, just to make sure everybody's understanding, nobody misunderstands, SSI, they don't do that. They will pay back pay to the date of filing, but they won't pay 1 year prior to filing.
And that's supplemental security insurance or income. Sorry,
Income,
income.
yeah.
And you've got a website page on that, and we've talked about that in numerous
Correct.
episodes.
Yes.
And I'll link to a couple of those in the show notes.
I just don't want somebody to
Yeah.
listen. He said, well, my Social Security was going to go back 1 year prior to filing, and it just went back to the date I filed. SSI just pays back to the date you filed. With Social Security disability benefits, also there's a 5-month waiting period. So if you become disabled May 15th of 2025, use that as the starting date of your disability. That's the date you last worked. And then May 16th, you had your surgery or whatever. Social Security says that you got to be disabled 5 months before they start paying you. So June would be the first month of the waiting period. October would be the last month of the waiting period. The first month they would pay you is November of 2025. So if you file February of 2026, they'd pay back pay to November of 2025. If you file February of 2027, even though you were found disabled in 2025, they're only going to pay back pay to February of 2026. So you need to file within 17 months of your onset date of disability, just so you don't lose any benefits.
Right. And friends, if you just listen to that the way I did, you'll understand it's complicated. At the end of the day, it's very, very complicated. But I think, having an attorney who can handle the comp and a Social Security disability claim allows you to begin to play chess a little bit rather than checkers. And sometimes you need somebody that can step back and understand the law in these two radically different systems. And how best to take care of you. Because, again, if you're facing a disability claim, it's going to be obviously a life-changing situation that you're dealing with. So having somebody that understands it and knows how to move it through the process efficiently as possible, but also understands those intricate details like you were just talking about, it's not something I'd want to try to handle on my own.
Well, I tend to agree with that statement a lot. Now, as I've said before, I do normally advise individuals to make the initial application themselves for Social Security disability. A couple of reasons for that. The primary reason is that the ones who are granted initially on Social Security disability, like I said before, statistically speaking, you're going to get denied, and the statistics are very high on denial of that first process. The few who are granted because of the severity of their medical issues. In my opinion, I don't think there's anything that an attorney's going to do to cause the case to be granted at the initial level, and in those cases, those people should not have to pay an attorney fee. But if I'm involved, I've got to charge an attorney fee if I've spent time on the case from that standpoint. So I typically tell people to file initially themselves. Now, there's certain instances where people have come to me and said they want me to help them file anyway, even after I tell them that, and that's perfectly fine, as long as they go in understanding. If you're granted, I'm still going to have to charge a fee because I've done work on the case. It kind of goes back to my motto to some extent, but back to the fact, I never liked taking my vehicle into a shop and them fix something and not fix the problem, and they replaced a part that wasn't really the problem, and now I got paid for a part I didn't need. I never liked doing that. That's kind of the way reason I work on the contingency fee in these cases is my percentage. I get paid a percentage of what I recover for the client. So if I don't do a great job for the clients, I don't do as good for myself either.
Yeah.
And so that's the reason I do that from that perspective. But I try to treat people the way I want to be treated. Don't always accomplish it, but if it's somebody who I think most likely going to be granted on their own, especially in that situation. I said, try to do it on your own, and if they deny you, come back to see me, and we'll do what we can to fight for you at that time.
Two quick points on that, friends. If you're listening to this, episode 76, and I'll put a link in the notes about this, talks about the listing of impairments for Social Security disability claims or Social Security claims. And that's what you're referring to, Jeff, right? There are certain conditions
Correct.
that if you're dealing with that, I don't want to say it's the fast track, but those are the ones that are probably going to get approved much earlier in the process.
Correct.
Yeah, and so I'll put a link in there if you want to listen to that. The other point with Social Security disability is, I think you've mentioned this in some of the earlier episodes, there's not really much you can do on that first attempt that's going to mess up your case, right?
Correct. 90% of the time, what they're doing at that first level is asking you what medical conditions you've got. Which, if you fail to list something, we can add it later. It's no big deal. What doctors you've seen for that for your condition, so that they can get those medical records, and then about your past work and what the physical requirements of the past work were for you from that standpoint. And so.
It's pretty standard stuff, really.
Yeah, very standard stuff, and a lot of it's going to be if I'm filling the form out, okay, what doctors have you seen? And then when you tell me, I'm writing it down. What were the physical requirements of your job? You tell me that. I may word it differently, probably would word it a little bit differently, but I'm still basically writing down what you're telling me in that regard. What are your conditions? And then I'd write them down. So it's the same. Information. I may phrase things a little bit differently on the initial part than what the client would, but they're not really going to do anything to hurt their case in that regard, in my opinion.
And as you said, statistically, that first attempt is probably going to get denied, and then that's when they can get in touch with you, and you'll help with that what I refer to as an appeal. You call it a request for reconsideration.
Request for reconsideration.
Yeah.
It's the technical term for it, but an appeal is the proper term too.
Okay. So, Jeff, let's talk a little bit about one factor that people need to think about when they're looking at should I file for disability or not, and especially with Social Security disability. The insured status requirement. Do you want to talk about that a little bit?
Sure. That's another thing that you need to be keep in mind, especially if you are hesitant to file for Social Security disability benefits. Social Security disability has one of the non-disability requirements is that you meet the insured status requirements, which means you paid enough into the system over the proper periods of time to be insured for Social Security disability purposes. Kind of like paying car insurance to some extent, or at least I like to liken it like that. So if I pay my annual premium today for my car insurance, then next year, if I don't pay that premium, I'm going to lose that insurance coverage on my vehicle. It's the same. If you pay into Social Security, pay your Social Security taxes in, then you're paying into Social Security. You're kind of like paying premiums. And then when you stop working and stop paying in, eventually you're going to lose the insured status requirements. If you work full-time for a period of time, it usually takes about 5 years to lose that insured status requirements, but it's all depending on what you paid into the system. So when I say usually takes 5 years, that's a generic, yes, that's about when it normally is if you work full-time for the past 10 plus years from there. But if you're a sporadic worker, you do seasonal type work or something of that nature, it may not be a full 5 years for you. And you have to be disabled prior to your date last insured, because once you go past the date last insured, you're no longer insured for Social Security disability. So if your date last insured was December 31st, 2025, you become disabled January 15th, 2026, you don't get Social Security disability benefits because you're no longer insured for Social Security disability January 15th, 2026. Now, if your onset, you didn't file to January of 2026, but your onset date was July of 2025, then you're fine because your onset date was before your date last insured.
Right. So, and once again, friends, these are the complex issues that you've got to deal with, and most of us just don't know. I mean, most of us just simply don't know because we've never had to deal with it before. But Jeff Roberts has 33 years now, just over 33 years of experience handling Social Security disability claims, handling workers' compensation claim, handling motor vehicle accident claims. And as we've mentioned before, sometimes one event can actually lead to all three of those claims for the same person, which is
Correct.
a little odd, but again, it's something that you could have handled, for that individual and that individual's family.
Yes.
Jeff, as we talk about Social Security disability, yes, you're based in Western Kentucky. You've got a primary office in Murray. You've got a secondary office over in Hopkinsville and Christian County. But when it comes to Social Security, you can actually handle cases all across the United States.
I can. Social Security has licensed me to practice in all 50 states. So I can handle Social Security disability claims in any state and have handled them in multiple states. The location of my practice, I tend to have handled more cases, obviously, in Kentucky than anywhere else, but also have handled several cases out of Tennessee from that. But yeah, I've handled cases in Alabama, Florida, Illinois, Missouri, a lot in other states as well from that standpoint. As I've jokingly said before, I'm still waiting for the person from Hawaii to call me up to handle their case. But yes, I handle those cases all over. I can handle those cases all over the country.
And if somebody wants to call you up, I mean, the fact is sometimes people have different numbers for different things, but really you've got one phone number depending on, regardless of where you are in the country and regardless of which office you want to go to. If you want to go to the Hopkinsville office, that's fine. If you want to come to the Murray office, let's talk about that real quickly.
Yeah, my phone number to reach me is 270-753-0053. You call that number, and that's the number to get my office. And if I'm not available to talk to you, they'll get some information from you, give that to me, and then we'll try to see. I'll look at see what I can do for you, and then we'll try to get you set up with an appointment.
Hey, Jeff, let's come back to one of the comments you made earlier in this episode as we're going to close this out. The decision to actually file a disability claim, as you said, can have some emotional factors involved, because again, we're used to providing for our families. We're used to being able to pay our own bills. And you've said across the table many times and said, hey, look, this might be something you've got to worry about. It's not something to be ashamed of. It's not something to worry about. It's not something that you're going to have to come in with a checkbook and hire an attorney like you would, for some other kind of case. This is done on a contingency fee. What would you talk to that? What would you say to that client who's really concerned about? I don't know if I want to take that step. I love the fact that you did explain that. Hey, we can take it off the board if you can get back to work.
Right.
But I don't think people want to hesitate with this because of some of these timelines that you talked about.
Exactly. Sometimes you do not want to hesitate from that standpoint. And, the conversation I have depends on the individual from that standpoint. There's not one set thing to say to someone. But usually, and it depends on their specific situation, but frequently I'm advising them in that regard and explain to them that while I know they want to be able to get back to work and hope they're able to get back to work, we've got to start planning for the future. And if they're able to get back to work, that's great. We can shelf the Social Security claim at that point in time and explain to them that the process that we're talking about, or that I'm talking about for them, is to protect them in the future and protect their family in the future so that they have this benefit coming in to help pay the bills if they're not able to get back to work. Some of the times, we've talked about this before, but I work on a contingency fee basis. Part of it is some people say, I'm not working, my money's tight, I can't afford to hire a lawyer right now, and I have to explain to them that, you don't pay me anything when we get started. I get paid at the end of the case. If we are successful in the Social Security claim, then I get a percentage of what I recover for you as far as the past due benefits that I recover for you. And it's not, some people are concerned that I'm going to be taking percentage of their benefits in the future. I don't do that. It's only on the past due benefits that we obtain that I charge an attorney fee. So
on Social Security disability
on
cases.
Social Security disability cases, yes. And so that's in those cases, I explained that to them, that there's no cost associated with it, that I advance the litigation expenses as well. And both of those are contingent upon recovery. So if we are successful, get my attorney fee and reimburse my expenses. But if I'm not successful in the claim, they don't owe me a penny for anything. So
Yeah, so I mean, very low risk. I know it's a big step, But again, it could make a significant benefit going forward if you're unable to return to work. You still got bills coming in. It'd be nice to know that, hey, Jeff was able to handle some of these claims and we worked through it. And ideally, depending on the facts of the case, turned out really well for us and enable us to kind of move forward.
Well, as I said before, I use it at times, or we use it at times, as a safety net if we can't do that. And it's good to have the safety net in place and not need it, then a whole lot better than to need it and not have it in place.
Yeah, fantastic. Jeff, I want to thank you for your candid advice on that. I mean, I love the fact that you're able to, kind of boil it down and say, this is my background. This is who I am as an individual, because you don't really hear that a lot. You see a flashy TV commercial or something like that. You don't really get to know the person. But I think, this is what, episode 123. I think over the years, we've gotten to know you quite a bit. And that's what I love about these podcasts is we're able to have very simplistic conversations about complex issues so that we walk away and really feel like we've actually added some value to people who don't know the law. It's not their job to know the law. That's your job, right?
That's my job, and been practicing law 33 years. I don't think anybody has ever referred to me as being flashy. So, and I don't think that's going to start anytime soon. I know you said flashy TV commercial, but in that regard. But yes, I've done this for a long time, and I enjoy representing my clients. I enjoy being able to help people out when they're going through difficult times from that, and obviously wish they weren't going through those times, but when they are, they're going to, and when they are having someone that can help lead them through that process, it can be very valuable to them, and I enjoy being able to do that and help people out when they're having difficulties. So.
Outstanding. Way to wrap up the episode. I think that's a good note to end on. So, okay. Jeff, thanks very much. We'll be back in a couple of weeks, and we'll talk to you then.
Thank you.
Take care. Bye-bye.
Bye.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.